there with you?
There's the court. Mr. Dwayne, Ms. Holland, ladies and gentlemen of the jury, good afternoon. As has been indicated, we thank you for being here. I think it goes without saying that we are here for some, this is a very, very serious matter. Mrs. Davis is here proclaiming her innocence in this matter. As has been read to you, this offense allegedly occurred between the 15th of November of 2020, November the 17th of 2020. Here we are, July the 13th of 2026, more than 5.5 years later. Now, as part of our opening remarks, we are to tell you what we expect the evidence to show. And also, it's my responsibility as the attorney for Ms. Davis to point out to you certain things that are important. One thing that lawyers like me are always, and prosecutors also, are always concerned with are timelines. When did certain things happen and at what time? Okay? And that's important for you to keep into consideration whenever you're listening to the evidence in this case and deciding this case. You will, at the end of the case, you will have a copy of the indictment that reflects all these charges that have been mentioned to you. This indictment was returned by the Houston County Grand Jury on October, or it was returned and filed in the clerk's office October the 18th of 2023, almost 3 years later. So the first thing that comes to mind is, why wait 3 years? Okay? And you'll see that the evidence will reflect in this case that this child died on November the 17th of 2020. Okay? That there was an autopsy done on this child soon thereafter by the GBI. But one thing that you'll see is that the autopsy results were not released for almost a year. And you have to wonder why. And maybe the state can clear that up. I don't know. We'll see. You will see that like I say, the autopsy report where the pathologist stated that this was a homicide, but based on a lacerated lip, like I say, was released, was signed off by the coroner, was signed off by the pathologist with the GBI, then signed off by the coroner almost a year later. Okay? So that puts us in 2021, a year later. Okay? And once again, this case was not indicted for 2 more years after then. Why? Those are things that you can take into consideration whenever you're studying this case and listening to the evidence in this case. And we'll hear witnesses in this case. And you know, one thing that I'm certain that Judge Adams brought to your attention today, and at some point in time Judge Lumsden will at the conclusion of this case, is that the burden of proof is always on the government to prove each one of these charges against Ms. Davis beyond a reasonable doubt. In other words, they have to prove each and every essential element of each crime charged beyond a reasonable doubt. Ms. Davis has absolutely no burden in this case. In other words, she can sit there and say nothing, and you can't hold that against her. She may or may not testify. We don't know yet. We don't know what the state's going to put up yet. But at the appropriate time, the judge will instruct you that if she should decide to remain silent, you cannot infer or insinuate or hold that against her in any way. A lot of people say, well, she needs to explain to us what happened. No, she doesn't. She doesn't have to. It's not her burden. She doesn't have to prove to you that her only child died because he fell off a bed or bumped into a table or on the handlebars of his little bicycle, that they're going to show you a picture of him on his bicycle. Or that it was done somewhere else, or who it was done by. You know, you can take into consideration the fact that she is jointly indicted with her then boyfriend, Kiyon Benton. It's my understanding Mr. Benton is going to come in the courtroom and testify. He doesn't have to testify. Now, you know, I mean, the state can give him some sort of immunity, but we'll see where that travels. That the boyfriend is not sitting there with us, but he's going to come in and testify against her. We'll see. Now, like I say, you need to take your evidence from the witness stand. This case, and understand, in my years of coming down here trying cases, and I've tried a lot of murder cases before, good jurors, where the charge of malice murder, and it'll be explained to you later by the judge, malice aforethought, something akin to premeditation or something akin to planning. In other words, someone had malice in their heart. You've heard the term of an abandoned and malignant heart. You've heard that before. That's why a murder happened. And in the alternative, the state sometimes will say, well, we think it's a felony murder based on another offense, a predicate offense, if you would, that as a result of that predicate offense results in the death of someone. And the felony murder, the first is cruelty to children in the first degree. And the indictment, of course, says that the baby died, was beaten with an object, the nature of which was unknown to the grand jury. In other words, they don't know how the child died. By what means? It was by a bowling ball or a baseball bat or whatever. Okay? That's for them to prove. And for them to bring their pathologists in here to prove to you. Now, some of you have medical experience. But they have to bring in, the state has to bring in evidence to show some sort of blunt force trauma, if you would. You know, there's also the felony murder charge of aggravated assault. And they don't know how, but they're saying that the injuries to the child resulted as a result of an aggravated assault or a weapon of some sort. You know, they have to prove that. But the difference in this case, I submit to you, in my experience in handling criminal cases, is murder in the second degree. That's different from what you generally hear in cases. That's generally different from, if you've been on grand juries in this county or any other county, you don't get too many murders in the second degree where they're saying that the child died irrespective of malice as a result of some sort of failure or neglect to seek medical attention for the child. And it gets a little complicated here, okay? Now, like I say, I don't know if Ms. Davis is going to testify or not, but you will see that the time that this happened, that she was, she's now 35 years old, she was a school teacher at the time. Teaching classes through the Central Georgia Technical College, where she was teaching classes in conjunction with the Houston County School District, as well as she'd go to Jones County, and that's, she was teaching on the days that this child, there will be testimony about him, his stomach hurting. You'll hear that. You will also hear that this child, he was 2 years and 10 months, Karter was, and that he wasn't even a week old and he was already having problems with breathing and asthma and things of that nature. And you will hear, we expect that you'll hear from the people that were treating him at this pediatric place that they treated him, that he was hospitalized, that he's always been a sickly child of some sort, as children are prone to do sometimes. And that at the time that, and of course the father of this child is this Karter Ambrose, and you'll hear from him. And he lived with Miss Davis during that period of time, and they'll talk about how they, I mean, we expect his testimony will be, assuming he's going to be here. But anyway, we expect the evidence to be that they lived together and then their relationship busted up, okay? But during their relationship, the decision was made by Miss Davis to move. She moved to this apartment complex off Lakeview Road, which is not even 3 football fields away from this pediatric place, so she could be near her doctors. And there'll be a bunch of people that will come testify, I guess, from the pediatric place that Miss Davis was there often with her child. Okay? And of course, the state would have you believe that that should mean nothing, that she moved where she was living at to be within 300 yards of where the doctor's office was at in case there were problems, because once again, the child, within the week after that child was born, was already in the hospital and exhibited sickly behavior or sickly symptoms throughout his young life. You know, once again, the responsibility is on the state to prove their charges against all these charges, all 7 counts, beyond a reasonable doubt. You'll hear the evidence, and I ask you, and I thank you for being here, because like I say, I mean, like this happened 5.5 years ago. Miss Davis has been patiently waiting to be sitting in that chair in front of a jury of 12 people plus 2 alternates to show you, to exhibit to you that she is not guilty of any of these charges. You know, I with you am patiently waiting to hear what the witnesses are going to say for the state. As Mr. Dwayne has mentioned to you, this is not a case of, you know, there's 2 types of evidence. There's direct evidence and circumstantial evidence. And Mr. Dwayne has said in his opening remark that there's not any direct testimony, or there's not going to be any direct evidence that that this lady or anyone struck the blows that ended up killing the child, okay? It's circumstantial evidence, okay? In other words, the circumstantial evidence that the state is proposing is that, and of course, the doctors are going to come in here, or the medical people are going to say, well, based on their experience, injuries of this type have to result, or can result, anywhere from 24 to 72 hours before someone dies. Not necessarily. Okay? And once again, it's not for Ms. Davis to have to come in here and point the finger at anybody. Okay? They're trying to prove that she committed these offenses. I submit to you that she did not. And, you know, once again, I don't know how adamant I can be to explain to you her innocence. I don't know how adamant she can be to explain her innocence. This is a long day coming from her, or for her. And, you know, I'll be able to ask questions of witnesses for the state. And, you know, once again, as I mentioned before, if there's anything that I do that upsets you or hold it against me. She has lost her only child. Her only child. Almost 6 years ago. She's not guilty of any of these charges, folks. Not guilty. Thank you, Your Honor.